I turned on my microphone. I want you all to know that. The House Court Subcommittee on Criminal Law will come to order. Clerk, please open the roll. Members indicate your presence. Okay, we have a quorum. In fact, we have everyone. Thank you. Excuse me, for the audience who isn't normally here, I have a problem on turning on my microphone at the beginning of the meeting, and I thought I was doing it, but excuse me. Now back to the docket that you have before us. There have been several bills that will go by for the day. This is a time in the General Assembly when people are working hard to get things in the proper order. The following bills will not be heard today. HB 441, Delegate Hope. HB 1105, Kilgore. And HB 1411, Schmidt. Do I have it all, I think? All right. And then it is also in order, based on our meetings before, a motion would be in order to table HB 875, which puts it in the right posture should the full committee decide to move it to general laws. This has to do with kratom.
A motion to table HB 875.
It's been moved and seconded that 875 be tabled. All those in any discussion? All those in favor say aye. Aye. Opposed? I'm sorry, we must go on the board. Clerk, can you please open the roll to table HB 875? HB 875 is tabled by a vote of 10-0 unanimously. Right. Now, in order, I don't see the members here who have bills having to do with judgeships. So, Delegate Gardner, I think that in fact you are the first non-committee member that I see. You have HB 240.
Yes, ma'am. Thank you, Madam Chair. First of all, I'd like to report the amendment in nature of a substitute.
Move the amendment.
It's been moved and seconded that we adopt the substitute for HB 240. All those in favor say aye. Aye. Opposed? You may speak to the substitute.
Madam Chair, can we have council report the amendment, please, the substitute?
Yes, Madam Chair, members of the subcommittee, the amendment in nature of substitute for HB 240 reword some of the language in subsection A to say that the judicial officer shall attempt to obtain and review the person's criminal history and any emergency custody orders. It also lists the TDOs, the IAs that are provided to the judicial officer. It also provides that any law enforcement officer bringing the accused before the judicial officer who has knowledge that that person is currently or has in the recent past been subject to those orders or admissions shall provide that information to the judicial officer.
Are there any questions of the language? Seeing no one wishing to speak at this time, would you like to proceed to present the bill?
And Madam Chair, if I do have one amendment to the substitute at this time. If we could insert on line 12 after the word and, insert the word review so that the sentence would read, the judicial officer shall attempt to obtain and review the person's criminal history and review any emergency custody orders. That is a recommendation of the Office of the Executive Secretary as a necessary amendment for this version of the bill.
So, excuse me, let me just follow what you're saying. You're attempting to obtain and review, but you're only reviewing the emergency custody or temporary. So you're not also attempting to obtain the emergency custody?
Yes, Madam Chair, and the Office of the Executive Secretary can explain that a little bit better than I think myself or Delegate Gardner can at this moment. It's based on who has access to certain records. That's why the rest of the language that's being added to that first subsection says that the law enforcement officer can bring their own personal knowledge to the magistrate. And I see that the OES is here, and they can help me out because I'm stuttering.
Madam Chair, members of the committee, Eileen Longenecker with the OES at the Supreme Court. The attempt to obtain and review the criminal's history would be the magistrate getting that from the law enforcement officer. There's a statute that says the law enforcement officer has to provide that to the judicial officer if they can. And then the language would say, and review one of those mental health orders that is provided to the judicial officer. So the magistrate doesn't have access to those orders. The magistrate shall review the orders if an officer provides with the magistrate with the order.
And the grammarian in me has one more word then. After and, it should be and to review. So you've got to obtain and review and to review. It's just clearer the separation of the two things. No, all right.
No, because the
Explain what I'm
attempt
missing.
to language would apply to both instances. One is attempting to obtain and review. One is attempt to review.
But you're obtaining and reviewing the person's criminal history, and it doesn't say that is that at the same time you're getting the mental health history. That's the problem that I'm having in making sure this is clear for interpretation out there from people who haven't been doing it.
Madam Chair, if it would be all right for me to comment, I think the attempt to obtain and review the criminal history is to ask the law enforcement officer for it. They're not attempting to review. If we insert another to in there, they're attempting to review the orders that are provided to them, but is the will of the committee. I would just recommend the word review there.
I'm sorry to the audience that we're going through this. So you're reviewing the person's criminal history that you attempted to obtain.
Correct.
Now you're reviewing any emergency custody order. When and how did I get that emergency custody order?
The language on line 14 is that is provided to the judicial officer. Review the order that is provided to the judicial officer.
And that is provided by whom?
It would be the law enforcement officer if they're bringing the person before the court, bringing them before the magistrate. This would apply to judges too. But if the officer knows that the person is currently under a temporary detention order, then he would provide that to the magistrate and show it to the magistrate so the magistrate could review it. Otherwise, the magistrate doesn't have access to all those orders.
And again, what I believe I've heard in your words is that that whole sentence is dependent upon the law enforcement officer bringing that material to the judicial officer.
Correct. By statute for the criminal history and by language in this bill, that if the officer has that, the magistrate can only review the mental health order if the officer provides that to the magistrate.
Again, I will accept your explanation, but not to say before full committee we don't make this absolutely clear about where this comes from, because unless we make it clear, there will continue to be situations where it's just not available.
And it may not be.
I understand that, and there the attempt is the right word, but I want to make sure that you have responsibility for making it available.
Yes, thank you.
Great. Mm-hmm.
Thank you, Madam Chair. Now, as amended, are we there yet? Okay. House Bill 240. On July 5th, Charles Byers' mother took him to the hospital as he was suffering a schizoaffective disorder. A mental health professional evaluated him and recommended he be placed under a temporary detention order. In the early hours of July 6th, a Richmond judge issued a TDO requiring Mr. Byers to receive mental health treatment in a psychiatric facility for up to 72 hours. Later in the afternoon on July 6, Mr. Byers was admitted to the psychiatric unit of the hospital. That same day, hospital staff called on-site police officers to help when Mr. Byers resisted moving to a more secure floor of the psychiatric facility. Body cam footage revealed a nurse told the police officer to, quote, take him, and he was ultimately arrested for kicking a nurse. He was removed from the hospital and taken to jail. The facility never communicated Mr. Byers' TDO status or dire mental health needs to the police. When Mr. Byers appeared before the Richmond magistrate on charges of assaulting the nurse, the magistrate released him back into the community, and he was as he was unaware of the active TDO that required him to be in the psychiatric facility. On July 8th, Mr. Byers was shot multiple times, including in the back, as he retreated and killed by a Chesterfield police officer during this mental health crisis. While there are many tragic aspects to his death, possibly closing this loophole and requiring this information to be provided may prevent another family from experiencing this. As you've already heard, the amendment for the legislation, it is to attempt to red flag these situations and provide this information to the magistrate. Had these amendments been in place on July of 2023, Mr. Byers' existing TDO may have been red flagged and been denied bail, and he would have returned to the psychiatric hospital instead of roaming Chesterfield neighborhoods where he was shot and killed in his compromised state. Thank you, Madam Chair.
Thank you, Delegate. Are there any questions of the patron? Seeing no one requesting to speak, is there anyone in the audience who wants to speak on behalf of House Bill 240?
Madam Chairman.
Thank you for coming again.
My name is Peggy Byers. This is my husband, Mike, and our son, Charlie, was the young man who was removed from the hospital and not told. The hospital didn't tell the officer that he was under a temporary detention order. My husband and I believe with our whole heart that had the magistrate known that he was under a TDO, Charlie would be alive today and have received the treatment that he's desperately needed. So we urge you to please support this bill so that no other family has to endure the tragedy of losing a loved one in such a senseless way. It could have been prevented. Thank you so much.
Thank you. Is there anyone who wishes to speak in opposition to HB 240?
Madam Chair, members of the committee, my name is Maze Yostein. I'm from the Legal Aid Justice Center. And to start, I am so sorry that this has happened to the Byers family. And I really appreciate Delegate Gardner's attempts to bring some clarity to the system. It was an absolute breakdown, and what happened to their child should never have happened. I'm just not sure this bill touches on the exact place where there should be an intervention. Our concerns at the Legal Aid Justice Center in our work with the pretrial Justice Coalition are that there will be unintended consequences to the language around, and I know there's been an amendment, which is much better, but the added information that the magistrate is supposed to attempt to obtain and review, could likely cause delays in a lot of other magistrates setting bond across the board for any charge. In addition, the idea that the communication between the arresting officer that was at the hospital and the jailer, those are the two entities that actually hold custody of the individual. The separate criminal offense, setting bond on that offense, is not involved in the same mechanisms. The magistrate setting bond on a criminal charge and the TDO that was meant to protect Mr. Byers and keep him hospitalized, that is about possession of the body. And those two things are not the same. And this bill in some ways confuses those in a way that could create some unintended consequences. As we said, and we stopped by and talked to Delegate Gardner's office because I so appreciate what she's trying to do here and would love to help work on it in the future, but we just have some concerns that we wanted to raise to you all. Thank you.
If I may ask a question,
Yes.
When you say in the future, are you prepared to work on it in the next week?
We'd be happy to. Yes.
Thank you. Is there anyone else here wishing to speak in opposition to 240? And we have online then, for 240, we have Sheba Williams from No Left Turns. Sheba? Apparently Sheba at this point hasn't signed on. I don't always do this in the right order, and my logic keeps on leaving me. I'm going to say first, Counsel, do you have anything to add before we hear last words from the patron?
No, we just had the same concerns that were kind of outlined by Legal Aid Justice Center with
The delay issue.
the delay issue.
Do you think there is a way that we can craft this so that we can get that fine line between information and not keeping people incarcerated for a length of time?
Potentially, if we can potentially pass it by and think about it, we definitely don't want people held longer while they're trying to get this information or see if it exists. But obviously, we want the judges to be considering all aspects, if they can, in determining a bail decision. So there may be a way to think about it. My only concern was just the delay issue, because this doesn't just apply to magistrates, it applies to all judicial officers. So if someone goes to court, a lot of times law enforcement is not at someone's arraignment if they don't get a bond from the magistrate. So then I don't know if prosecutors will be trying to track down these things and not be prepared to address bond. And it may be in conflict with the bill that Delegate Carlson has passed through the subcommittee with regard to bail at first appearance and counsel at first appearance. So if there's a way we could kind of get those in conjunction.
That fine
with it. Yeah.
needle.
Madam Chair?
Yes,
Given,
Delegate Delaney.
thank you, Madam Chair. Given council's words and the testimony we've heard, if the patron is interested in continuing to work on this over the coming days, I'd make a motion that this bill go by for the day.
Would you take that as a friendly motion?
Yes, Madam Chair, that was my attempt in trying to change the language to get it not to hold people over, but to make an attempt to get this information if it's available.
Okay, it's been moved and seconded that as amended, HB 240 go by for the day. Thank you very much for the discussion.
Thank you, Madam Chair, Subcommittee.
Chairman Hope, do I see everyone in the room that we can move on the judicial bills and yours? Yes, we are, but I just wanted to make sure all parties were here to be rolled in a friendly way.
David, I don't know if you wanted to come up at all. I know Delegate McQuinn has a bill also. I told her she didn't have to come.
I have before me, I have HB 46 Reed, HB 194 McQuinn to be rolled into your HB 443, all having to do with additional judgeships.
Right. That's right. And let me go ahead and present that, House Bill 443. This bill is a recommendation of the Committee on District Courts and Judicial Council of Virginia. It's adding 2 judges in JDR 12th and 15th, 2 in the GDC on the 12th and 26th, and the Circuit Court 2 judges in the 20th and the 27th.
Delegate Reed, would you like to speak to your bill, HB 46, as it is part of HB 443?
Just one. Yeah, just one. I thought I heard you say 2.
No.
Oh, I see. Okay.
Just one circuit.
Okay. All right. Thank you, Madam Chair, and I'll try not to take up too much of your time, and I appreciate the Chair of Courts. What? After you've made the sale, stop talking, right? So I do appreciate the Chair of Courts and the work that he's been doing on this. As you look at making the decision on the additional circuit court judge for the 20th Circuit, I just wanted to highlight a couple things. The 20th Circuit right now has the greatest imbalance in the Commonwealth for the judge to resident ratio. And that's partly because the 20th Circuit, which includes Loudoun, Fauquier, and Rappahannock, has had tremendous population growth in the last 10 or so years. We've grown by 310 residents, and the last time a judge was added was in 2015. And unfortunately, right now, what that means is that there are current docket delays that can range from 15 to 23 months, which really adversely affects individuals' access to a speedy trial. So I appreciate everything that you're doing and the consideration for this, and greatly appreciate the work that the chair has done in being able to move this forward, and hopefully we'll be able to have an additional judge in the 20th Circuit.
Thank you for that background. At this point, we can have the motion a motion to move to incorporate HB 46 into HB 443.
So move.
Second. Madam Chair, if I might just add, especially for the newer members, we're constantly evaluating the caseloads that are coming in to the different courts, to Delegate Reed's point, and evaluating whether an extra judicial resources are warranted given the increase in caseload. And so this process went before the Committee on District Courts and Judicial Council, and this was their recommendation. And so this is the process that we go through to make sure that we are adequately resourcing our bench.
So would you like to then summarize your bill with the incorporation of McQuinn? And I'm sorry, we're going to have it was a voice vote. Yes. Yeah. So that if you would like to summarize what's in 443, or just say that it's needed.
For the juvenile domestic relations courts, we're adding 2 judges in the 12th and the 15th. General District Court, we're adding 2 judges in the 12th and the 26th. And for the Circuit Court, adding 2 judges, 1 in the 20th and 1 in the 27th.
Thank you. Again, in the absence of Delegate McQuinn, I believe that I'm still going to ask for an amendment to incorporate her HB 194, which deals with the 12th Judicial District, into your bill.
So move.
Second.
And that's a voice vote. All those in favor say aye. Aye. Opposed? Okay, so now it is before us. We have everyone incorporated for General District, Juvenile and Domestic, and Circuit Court judges that have been approved. And this is a report and refer to appropriations. As a substitute. And as a substitute. Okay, got it. Whatever. I'll get all this language, but all right. So a motion is in order to report and refer the substitute, which incorporates the other 2 bills, up to report and refer. I think we've made it. Okay. Please open the roll. Members, cast your vote. And the motion to report and refer the substitute to appropriation passes by a vote of 9-0. Thank you very much, Mr. Uber Chair. Okay.
Did you want to do 1485 also in that block?
Mm-hmm.
House Bill 1485, I will have an amendment, but I did want to talk about what the bill does. In the same vein that we're constantly evaluating our caseload to making sure that our judicial resources in particular courts have those resources, we're proposing to increase the number of Court of Appeals judges from 17 to 21. We're looking at restrictions en banc to no fewer than 13 judges, and a third provision is summarily affirm for certain civil cases. Again, let me talk about the increase of the Court of Appeals from 17 to 21. They've seen a pretty big explosion since we expanded the court of jurisdiction. But even since then, and we've been monitoring this, probably for the last 4 years, I'd say, we've settled in the caseload, but still seeing an increases in cases that have been initiated. In 2025, 2,232 cases were initiated, about a 6% increase over the 3-year average. Case categories have objectively increased. Civil cases and domestic relations cases have also increased. In 2025, there were 712 civil cases. That's a 15% increase over the 3-year average. 250 domestic cases, that's a 22% increase over the 3-year average. From 2019 to 2025, motions increased by over 125%. These additional judges that we would add to the court and staffing increases will help move the cases through the appeals process more efficiently by increasing the number of available annual argument panels. And so this will be helpful to, when you're filing your petition to the date of getting your time to decision, that is unacceptably a high level. There are certain cohort of cases that are well over 500 days until you're getting that decision, and having these new judges will be able to get that closer to a reasonable area. The second area of en banc structure revised the languages that allow the court to perform its en banc function by such a number of judges as may be prescribed by the rule of the Supreme Court of Virginia, provided that the court sits en banc with no fewer than 13 judges. So allow some flexibility there. The rotation of those judges established by the en banc sessions there'd be more time for judges who are not sitting for a particular case to be focused on assignments onto other panels, helping promote more efficient workflow. So having this provision in there will help make things more efficient throughout the entire court. Finally, the third provision that would allow for summarily affirm for certain civil cases this bill will allow for more efficiency of the court to summarily affirm decisions in certain civil cases that are clearly governed by settled law. This allows judges to focus more time and energy on complex issues. The provision would allow the court to decide very specific subset of cases through a summary affirmance process, much like other appellate courts do in the country. If the subcommittee would permit, I would like to offer an amendment that would affect the effective date to be September of this year, of 2026. And so it'd be like if someone could move that.
Move the amendment.
Second. Any discussion? All those in favor say aye. Opposed? It is so amended.
The reason for that amendment is that the cases for the entire year are pretty much already scheduled. And so in order to get them in time for starting in 2027, the judges would need to come on probably September timeframe to integrate them ready into 2027. So that's the reason for the entire bill to be effective at that date.
Seeing no one requesting to speak, is there anyone in the audience who would like to speak in favor of HB 1485? Anyone opposed? And I don't believe we have anyone online, so, and council has no comment, so Mr. Super Chair, you have the final word.
I appreciate the subcommittee's indulgence. Again, this is just a process that we've been watching for the last several years. The new court has settled in since we expanded in 2021, and so we've been watching to see how the caseloads, just like every other, like the previous bill I brought, making sure that the caseload, that we have enough judicial resources to match the caseload so that we can get that time to decision down. And so it's been concluded that we need an additional judges in order to make that possible.
Thank you for your work.
Madam Chair.
A motion is in order then to report and refer 1485 as amended to appropriations.
Could I have just one question for the patron? Were we facing a bubble and this might go down, or is it just going to constantly it's leveled out?
Well, Madam Chair, I mean, I think, one of the statistics that I got from the court was that we're seeing it go up, and we think that with the new judges, they'll be able to level that process out so that will bring the time to decision down. We've been watching this for a couple of years, and so we've deliberately given it time to make sure that it wasn't a bubble, that it was in fact a trend. And so we're confident that this level will meet that expectation of growing caseload. And of course, in the end, bring that time to decision down, because that's really the purpose of this. When you file a petition to get your time to decision, in my opinion, that needs to be close to a year, because people are waiting in prisons, they're waiting for their case to be resolved. They shouldn't have to wait longer than that. And that was the case prior to the previous expansion of the court of jurisdiction, but we want to get to that level place.
Follow up?
No, thank you.
And that also then underscores your decision to reduce a little restructuring to try to efficiently use the judges. All right. Again, a motion is in order.
Madam Chair, move to report as amended and refer to appropriations.
Second.
And moved and seconded. Any questions, concerns? Speaking to the motion, please open the roll. Members, cast your vote on reporting and referring 1485 as amended to appropriations. All members have voted. It is reported and referred with the member to appropriations unanimously by a vote of 10-0.
Thank you, Madam Chair.
Okay. So now as I look out at the audience, we have on HB 648, Delegate Kent. And Delegate Kent, on that one, you have an amendment yet before us?
Yes, ma'am. I do have an amendment I'd like to move, please, on 648.
If you can,
Amendment?
and if you can report the amendment.
Thank you, Madam Chair, members of the subcommittee. It should be posted online now. This is an amendment in the nature of the substitute. It changes the existing subsection C provisions, which are now listed as D on line 24. It strikes all the language on line 25 about applying to persons under 18 years of age for any purpose, and instead says that you cannot sell these devices to any person with the intent to intoxicate, inebriate, excite, stupefy, or dull the brain or nervous system of such person, but does say that the subsection shall not apply to any person intending to sell, distribute, or offer to sell or distribute to a practitioner as defined in 54.1-3401, and any person who violates such provision is guilty of a Class 1 misdemeanor. I'm just noting that the same carve-out for a practitioner is noted in existing law for unlawfully, for any person to unlawfully deliberately smell any drug of that nature with the intent to inebriate, and the intent language does exist in current law for the inhalation or enticing someone else to inhale. And that's the substitute before you.
Okay. All right, we had considerable time on this, Delegate Kent, at our previous meeting, and I'm going to ask your indulgence one more time to go by. And the reason for it is I was just rereading it, and I have problems with the fact that the amendment at the top of line at 26, the top of the second page, now says you can't sell it with the intent to intoxicate, inebriate, excite, stupefy, or dull the brain. It doesn't stop sales in any given store. We've allowed it when it deals with food preparation, manufacturing, and healthcare providers. But now we're saying that it can still be sold anyplace else, but it just can't be sold with the intent to inebriate, excite, So I would ask your indulgence, Delegate, to take this by one more day, one more meeting, and see if you can get agreement, because I don't think, from what I heard in your testimony, that that's in fact what you, if you want the vape shops to go ahead and keep selling it without talking to anybody, then that's what your bill will do.
I'm happy to keep working on it. We certainly want it to be right. So I'm so grateful for Mr. Hetcher and Ms. Pauls. We worked on it some this morning, and so we wanted to make sure we were classifying that the intent is to intoxicate and not just for sale. So I'm happy to keep working on it if that's the will of the committee to make sure it's right. And I can bring it to you if that's better before we come to committee on what we work on, just to make sure before we come in advance. If that's agreeable.
So a motion is in order to go by for the day.
Madam Chair, I move that HB 648 go by for the day.
Any discussion? Delegate Williams? And Delegate Carlson first.
Thank you, Chair Watts. Speaking to the bill, I tried to text you this earlier. You had a lot of great comments come from the public that gave very specific examples of things that shouldn't be happening. Selling these in vape shops where it's clear that that's what the intent is. Marketing that makes it clear that the only reason you're buying it is for its intoxicating effect. One of the people mentioned not having an ID check. All very clear, specific safeguards that I would love to see in the bill, because I concur with Chair Watts that as written, it's just not clear, and you're catching a whole lot of things. You're either catching a whole lot of things you don't want to catch, or you're not catching things that you do want to catch. So I look forward to seeing the next version, and I appreciate your willingness to work on it. And I would love to see that kind of specificity to target what you're trying to target.
Yes.
Delegate
Chair
Williams,
Watts.
did you want to comment?
Yes, Madam Chair, I took this bill home and worked on it too, to try to get it right. So I also have like a substitute that I'd like to run by the committee at some point. Now's not the time. So I think the motion in front of us is passed by for the day. I'd like to pass by till like Friday, so we know when we're coming back.
That would be certainly agreeable to the schedule as I know it. So the motion before us then is to pass by HB 648 until Friday.
Thank you so much.
All those in favor say aye.
Aye.
Opposed? Okay.
Thank you.
So now we are left with Mr. Uber Chair, HB 885, followed by, haven't forgotten, 520 for Hernandez. But I'm being deferential.
Thank you, Madam Chair. There's a substitute, isn't there? Yes, I knew there would be.
Move the substitute.
Substitute is before us. Would you like the council to present the substitute, or would you like to?
Of course.
Yes, Madam Chair, members of the subcommittee, I'm working on getting it posted online. The substitute for 520 is basically a skinny, nope, that's the wrong bill. So, see, substitute for which bill? 885. Yes, that is the court date reminder bill. Y'all didn't have so many substitutes, I wouldn't know which bill it is. This is the skinny version, pared down version that has much less of a fiscal impact. It still gets to the intent of the program, which would be to send out these reminders to defendants to remind them of the court and their court dates. It also includes a longer enactment clause that talks about convening a work group in order to review the provisions of this bill to see how to implement it. And as a result of that, there is a delayed effective date on the provisions of the first enactment of this bill, which would be January 1st, 2027. So if this bill were to be passed, all the statutory language would go into effect, but not actually become effective until January the 1st. And this work group could meet to talk about how they would actually implement the provisions of the bill. And a report would be submitted to everyone by December the 1st, 2026.
Thank you. Are there any questions of the patron or of council? Delegate, no, I see no one wishing to speak.
We need to adopt the substitute. We need to adopt the substitute.
We have not done that. Please move.
Yeah, I'll move. I'm going to move the substitute.
It's been moved and seconded to adopt the substitute 885. Any comment? All those in favor say aye.
Aye.
Opposed? Okay.
Thank you, Madam Chair. I think everyone's familiar with this concept. When you need to go to the dentist or doctor's office, they text you. They tell you if you're coming. They remind you to come. This sets up a statewide court text reminder program to go to court. The goal is simple: reduce missed court dates that occur because people forget or misunderstand their court requirements. They're not really intentionally trying to avoid court. They just sometimes aren't able to be there. Passage of this bill and incorporating this statewide court text reminder program will improve court efficiency. It will reduce avoidable jail time admissions, driver's license suspensions, and other collateral consequences that come from it. According to a recent national poll, 50% of respondents who had missed court that they had either forgot about the hearing, didn't receive notice, or the information they did receive was confusing. All reasons that could be addressed with automated court reminders. This would be it's a voluntary program to participate if you want to provide your information. Virginia already has one, but it's an opt-in one, and it has very little uptake. This will create, more broadly, more people will be involved. Law enforcement must, to the extent practicable, obtain phone numbers while issuing charging documents. So we made it, they try to do it in order to get that information. I mentioned that it was voluntarily. Phone numbers may be used only for the court date reminder program. They may not be used to investigate or prosecutorial purposes at all. But so that's the bill before you. I will say, I believe I saw a statistic that the sixth most likely reason to get someone arrested on a warrant is failure to appear in court. And when they've tried this in other jurisdictions, it has a massive decrease in people failure to appear. I talked to my circuit court clerk about this, very excited about something like this, because you imagine you go to court, the judge is there, the lawyers are there, everybody's there, the defendant fails to show up. And it takes a lot of time out of the court's schedule to do that. Issuing warrants for arrest and things like that, pulling people over and arresting them and bringing them. It creates another misdemeanor, creates perhaps another felony. This just makes perfect sense to make our entire system more efficient. And that's the bill, Madam Chair.
Excellent. And as I see the time frame in the enactment clause, you have a work group that is to report by the end of the calendar year, December 26th, and the bill goes into effect at the beginning of the next calendar year before we convene in the next session.
That's right, Madam Chair.
Delegate Williams?
Yeah, speaking to the bill, I'm a big fan of this. I hope that we can pay for it because I think it will save money.
Yeah.
And I think it will do a good job for just the whole system. So thanks for bringing it.
Thank you. Thank you very much, Delegate.
Would you like to engrave that on a plaque?
Hi, Chief Co-Patron.
All right. Are there other comments wishing to speak? If not, is there anyone in the room who would like to speak in favor of HB 440, HB 885? Please proceed. I see if you all can split 4 minutes.
Thank you, Madam Chair and subcommittee members. My name is Isabel Shapiro from the Pew Charitable Trust. I'm here to testify in support of HB 885. In Virginia, missing court can have serious consequences both for the courts and the communities they serve. When someone doesn't show up for their hearing, it slows down court operations and wastes the valuable time of judges, attorneys, and court staff. For the person who missed court, it can lead to a KPS or a bench warrant, a suspended driver's license, new criminal charges, arrest, and jail, even if they simply forgot. In fact, our preliminary analysis of Virginia data shows that failure to appear is the #1 reason for custodial arrests in the Commonwealth. But there is good news. Rigorous research consistently shows that sending people text message reminders before their court date can increase appearance rates by 20 to 40% and reduce collateral consequences. Virginia already has the basics of a court reminders program, but only 16% of eligible cases are enrolled. By moving to automatic enrollment, House Bill 885 will dramatically expand the number of Virginians who receive court reminders, increasing efficiency in courts and reducing unnecessary arrests and jail admissions for missed hearings. The Pew Charitable Trust strongly supports the bill, and we thank Delegate Hope for putting it forth.
Thank you. And I will add a minute to the time, so it's a total of 5. When we're done, we'll go on for another minute.
Madam Chair, members of the committee, my name is Kenneth Hunter. I'm with the Virginia Interfaith Center for Public Policy. I won't do this long diatribe I had planned, but I do want to say that this is practical because I have family members who are really suffering from this, losing all of the collateral consequences from missing a court date. And I wouldn't be able to see you if it wasn't for reminders that send me to my eye doctor and send me to my dentist. And this has much larger consequences, so it seems like a practical thing to do. We support the bill. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee. Anna Kurian from Legal Aid Justice Center. When someone is out on bond, a judge has made a decision that this person should be at home while their case is being adjudicated. When that person is rearrested, we're wasting precious resources that court stakeholders have, and so we'd ask that you support this bill.
Thank you.
Good afternoon, Madam Chair, members of the committee. Cammie Blatt with the Commonwealth Institute, and we support this bill. We rely on reminders for nearly every important obligation in our lives, and court dates with such serious consequences attached should be no exception, especially when missing court can lead to new charges, arrest warrants, license suspensions, and jail time. Most court dates, like we've heard, are when people forget or misunderstand instructions, lose paperwork, or are balancing work, childcare, and transportation. Research shows about half the people who miss court cite confusion or lack of notice. By improving appearance rate, this bill will reduce costly downstream consequences of missed court dates, including rescheduled hearings, failure to appear charges, and unnecessary jail stays. And for this reason, we ask that you support this bill. Thank you.
Madam Chair, members of the committee, Robert Melvin with the R Street Institute. We believe that, and we have seen that this measure in the 6 other states have adopted it. It's gone and it's reduced failure to appear rates. It's been incredibly beneficial for making and increasing the efficiencies in their system. And for those reasons alone, we ask you to go and pass this measure. Thank you.
Good afternoon, Madam Chair, members of the committee. Sean Winetta speaking on behalf of the Humanization Project, as well as Sheba Williams just reached out and asked me to speak on behalf of No Left Turns. And for the reasons previously stated, we all do support this bill. Thank you.
Thank you.
Good afternoon, Madam Chair and committee members. Greg Brown with the ACLU of Virginia, and for all the reasons stated, we support the bill. Thank you.
Good afternoon, Madam Chair, members of the committee. Mackenzie Babachenko, Commonwealth's Attorney, Hanover County. I echo the comments made by Delegate Williams. This is a great idea if it could be funded, and I want defendants to show up to courts. Good for victims, good for witnesses, good for the people being charged. So I support the bill.
Thank you. And do we have anyone in the room who wishes to speak against 885? Online, then, we have one individual speaking for, one speaking against. For is Kimberly Dyke-Harsley. Kimberly? And us not seeing Kimberly, is Ann Tatis on? Speaking against? Okay, I do not see anyone then wishing to speak remotely. Are there any questions? Are there any concerns expressed by counsel that we should be aware of? You have the final word.
Madam Chair, I've been working very closely with OES on this. They've requested delayed enactment of July of 2027, and I'm delighted to accommodate.
Okay, so your work group reports at the end of 26 for an effective date for July of 27.
Yes, and I would ask that that be an amendment.
I hear that amendment.
Move the amendment.
It's been moved and seconded. All those in favor say aye. Aye. Opposed? Okay. The bill is now before us in its amended state. Final word.
I appreciate the time of the subcommittee. I hope that we can pass this common sense
All right,
measure.
so the appropriate motion is going to be report and refer the substitute as amended to appropriations.
So move.
We're cheering for you.
And I see no one wishing to speak, so we're going to roll the train. Mr. Clerk, please open the roll. Members, cast your vote. Okay. HB 885 reports and refers with substitute as amended to appropriations. Unanimously vote 10-0.
Thank you.
Thank you. And now, Delegate Hernandez, it's you're up with HB 520. Delegate Hernandez, please present.
Madam Chair, and with apologies to Troy in particular, I do have a substitute.
Move the substitute.
Okay, the substitute is before us for HB 520. Council, would you like to present it?
I say, Madam Chair, members of the committee, fortunately for Delegate Hernandez, I did post this one online a little early. But this bill now matches Senate Bill 82, which is a Senate cognate. This language, it's added to clarify about when the person getting access to the OCRA is in the jurisdiction served by the clerk, provided that the attorney getting access to this software is also representing a defendant in that jurisdiction and agrees to continue accepting appointments. And then it also adds a paragraph about how the clerk has the ability to revoke said access to the system for certain reasons.
Are there any questions? All those in favor of the substitute, please say aye.
Aye.
Opposed? Okay.
Thank you, Madam Chair. So this is HB 520 with substitute. I would just note from the jump that this bill is an official recommendation from the Indigent Defense Commission, and it's a straightforward bill. It simply waives the OCRA fees for currently certified court-appointed attorneys in the jurisdiction where they are taking cases. We want to alleviate the fees here for really a straightforward reason, which is that we are losing across Virginia folks who are willing to serve as court-appointed counsels. By a recent count that I was given, we're under 1,000 at this point. And so this is just one step that we can take to remove a barrier to help them more easily and at no cost access electronic court records remotely. And this will also help localities keep these sorts of attorneys on court-appointed attorney lists. So the last thing I'll clarify that clerks are still able to charge law firms, other kinds of attorneys. It's really just limited to these court-appointed counsel. So with that, pretty straightforward bill. Hope it will be the will of the committee to support it.
Are there any questions of the committee? Yes, Delegate Davis.
Thank you, Madam Chair. I just have a comment. I think this is a good bill and appreciate you bringing it. I just have concerns with line 33. At the end, is found to have abused such privilege of such secure remote access. I think we have no definition for that, and that concerns me. But that's about that. Otherwise, I think it's a good idea. Thank you.
Thank you.
Seeing no one else wishing to speak, is there anyone in the room who wishes to speak in favor of HB 520?
Madam Chair, members of the committee, Allison Powers from the Indigent Defense Commission. And Delegate Hernandez said it better than we could have. This is an official recommendation of the IDC. And just wanted you guys to keep in mind that over 50% of the jurisdictions are represented by court-appointed attorneys. So this is just one small way we're trying to keep people on the list and lure them back as well. And I'm happy to answer any questions logistically about OCRA.
Thank you.
Madam Chair, Rob Hogan-Class from Justice for Virginia. And just a reminder for anyone who didn't read the 2023 JLARC report on court-appointed attorneys, we've had a 50% drop-off in the last 5 years of court-appointed attorneys. OCRA access is one small thing that can make a court-appointed attorney's job easier to do. So this is a great bill, and we fully support it. Thank you.
Thank you.
Good evening, afternoon, Madam Chair, members of the committee. Carlos Hopkins, Gentry Law with the Virginia Court Clerks Association. And Madam Chair, just to answer Delegate Davis's question, some of that language was language that we had worked on with the patron and with the IDC to ensure that those persons who were receiving the benefit actually were on the list. Most of the folks on the court-appointed list all have a subscriber agreement, and that's what's referenced in terms of the abuse. And so that's why that language was included, just to make sure that we narrowed it to people who are actually on the list who receive that benefit.
Thank you. Is there anyone in the room wishing to speak in opposition to 520? Seeing no one and seeing no one online, Counsel, do you have any comments? Delegate Williams.
Madam Chair, a question for the patron.
Mm-hmm.
I'm a practicing court-appointed attorney. This would be super helpful for us.
I'm doing it for you.
I would like it. I hope it's not like super expensive.
It's not.
All right. Seeing no one else wishing to speak, you have the final word.
Madam Chair, I can't say any better than that. I hope it will be the will of the committee to support the bill.
Move to report.
Okay, it's moved to report and refer
to appropriations.
a substitute, and it was not amended, correct? The substitute is, no, okay. So it's report and refer the substitute.
So moved.
It's been moved and seconded. Any discussion? Clerk, open the roll. Members, cast your vote. HB 520 is reported and referred. I did, but I want to make sure that this says report with substitute. I thought it was a report and refer. Am I wrong? I'm wrong. Okay, then you got it right. Thank you, Mr. Clerk. So it's report with substitute unanimously 10-0. Okay, if you would take over the chair, we've got 2 more bills.
All right. Madam Chair, when you are ready to present House Bill 246, the floor is yours.
Okay. Let me do them in numerical order. HB 246. And I don't believe I have any substitute on it as before you. What it is doing is it is providing for an affirmative defense to prosecution if the person has been charged with assault and battery on a law enforcement officer. And the person has to prove in that affirmative defense whether that a preponderance of the evidence that at the time of the assault or assault and battery, that person's behaviors were the result of either a mental illness or a neurocognitive disorder, which includes dementia, as well as autism, or an intellectual disability or developmental disability. And or that the person met the criteria for an issuance of an ECO. So we have, as I stop there for a moment, I have always understood why in a crisis situation, that the law enforcement and the individual may well be in physical contact with each other that would lead to a charge of assault and battery. And it is a felonious charge when it is against a law enforcement officer. So while I understand that, it's what comes after that. And this says by a preponderance of of the evidence, you give the individual an opportunity to lay before the judge what the background to their behavior. Now, the person must give notice in writing of intention to present such evidence to the Commonwealth's attorney at least 60 days prior or at least 14 days prior if the trial date is within 21 days of the last court appearance. And if the notice is not given, the person proffers such evidence at his trial as a defense, the court may either allow the Commonwealth a continuance if the Commonwealth wants to proceed with that information, or, under appropriate circumstances, bar such evidence. You get a chance to notice. If you don't do it, then the court has the option to bar the evidence. And if the person doesn't approve that his behaviors were a result of his mental illness, intellectual disability, developmental disability, or neurocognitive disorder, even though the evidence establishes such a condition contributed to his behavior, but it were the result of, the finder of fact may find such a person guilty of misdemeanor assault or assault and battery. That is also the option as opposed to felonious assault and battery. So you've got a number of options then that are before the court in prosecuting the charge of felonious assault and battery against a law enforcement officer.
Thank you, Madam Chair. Are there any questions from the committee? Seeing no one, I will ask if there's those in the audience who would like to come forward and speak.
Thank you, Madam Chair.
5 minutes on the board.
My name is Brian Kilmar. I'm the president and co-founder of Decriminalized Developmental Disabilities. During a crisis, a person with autism or other developmental disabilities may unintentionally make physical contact with the first responder, not out of aggression, but because of communication, sensory, or processing challenge. This bill recognizes these realities and ensures disability-related behaviors are not misinterpreted as a criminal intent. Families call 911, 988 because they're desperate for help when their child is in an autistic meltdown or overload and needs support. But when first responders arrive, the sensory overload, unfamiliar faces, rapid commands can overwhelm an autistic person. In that moment, their fight or flight response can override their executive functioning. What may appear as an intentional assault is often an involuntary defensive reaction to fear and not aggression. This bill protects families who seek help and ensure autistic individuals are met with understanding and appropriate support, not a felony charge for a reaction rooted in a disability. Under current law, that moment can lead to a felony conviction and mandatory 6 months in jail. Jail can be dangerous for autistic individuals, and a felony record can mean losing services, supports, and any realistic chance at a stable employment. This bill recognizes the reality of autism and allows people to receive support early instead of pushing into incarceration. It protects families who seek help and prevents the criminal justice from becoming the default response to employment or to their disability. I also want to note there's a financial impact. For the past 2 years, this bill has passed through the General Assembly without any financial impact. Nothing in the process has changed. The defense still carries the burden, the prosecutors still oppose it, and the courts already have authority to order expert testimony. This bill does not create new costs, it simply creates a fair path. I hope you approve this bill. Thank you.
Thank you.
Hi, I'm Tanya Milling, Executive Director of the ARC of Virginia. Thank you so much, Madam Chair, for bringing this. This has been part of long work. As Brian said, it has passed previously last year with bipartisan support, and so we truly hope and urge you to pass the bill. Thank you.
Thank you.
Good afternoon. My name is Rebecca Herbig. I'm with the Disability Law Center of Virginia, and we support this bill. Thank you.
Thank you.
Rob Hogan-Class with Justice for Virginia. We strongly support this bill. Thank Delegate Watts for her years of hard work. I think if this bill were a child, it could go to kindergarten by now. It's been a long process, and we, over many years, have refined this language and really appreciate all the folks willing to come forward and support this bill. It's going to make a big difference to some families who are experiencing some of the worst times in their lives. Thank you.
Thank you.
Thank you. Maisie Osteen, Legal Aid Justice Center, and we support this bill. Thank you all.
Thank you. Alexander McCauley for the National Alliance on Mental Illness, and we support the bill. The NAMI is comprised of primarily family members, and overwhelmingly our membership believes this is one of the most important bills that has come before the General Assembly in quite some time. Thank you.
Thank you. Is there anyone in the room here to speak in opposition?
Good evening, Chairwoman. My name is Bethany Harrison. I'm the Commonwealth's Attorney for the City of Lynchburg, here on behalf of the Virginia Association of Commonwealth's Attorneys in opposition to House Bill 246. Here under subsection C, we only cover a certain class of people where an affirmative defense is created. So if someone is at a store and if they are having, if they have mental illness or neurocognitive issue and they assault the clerk of the store and they have to call the police, this person is charged, the police officer is charged with coming in and dealing with the situation, and the police officer is also punched or kicked, hit, spit upon, that this person, defendant, now has an affirmative defense to the same conduct toward that law enforcement officer that there is not an affirmative defense toward the clerk of the store. So the inconsistency and inequality there of the victims, including judges, magistrates, law enforcement officers, corrections officers, jail officers, Department of Juvenile Justice officers, firefighters, EMTs, and folks who work in certain capacities in the Department of Behavioral Health are the ones who are no longer protected with this. We had an example of unintentional physical contact. If there's unintentional physical contact, then we can't prove the elements of the offense. So this is the person who is saying, I'm going to punch you, and punches the officer or looks dead at them and assaults them anyway. There is also already a provision for this under 19.2-33.6 that allows for a deferral of even this charge for autism, intellectual disability. It can be amended to include some of these other categories that are included in this bill. And also along with it, there's no plan for treatment. There's no, guiding the person into a resource to prevent this from happening in the future. Instead, it's just a defense. It's just you get a pass on assaulting this officer or hurting this officer. So for those reasons, VACA opposes the bill. Thank you.
Thank you. All right, turning online. Speaking for the bill, first I have Dr. Taj Bahan-Haft for the Humanization Project.
Thank you. Chair and members of the committee, Taj Bahan-Haft, the Humanization Project. Also the sibling of an autistic educator, so I've seen this up close, how this works. In addition to all of the reasons that we've already mentioned, we support this bill, but also because we should not be criminalized something that science is increasingly telling us is simply a difference in how human beings engage. And I can see in my own sister's experiences that there's a number of times where just trying to work with somebody based under current laws here would allow people to end up incarcerated for simply trying to work with their teacher when things got out of hand outside of people's control. That's just not an acceptable approach to criminalizing anything. So thank you very much.
Thank you. Next we have Teresa Champion, Virginia Autism Project.
Thank you, Madam Chair. I'm with Teresa Champion with the Virginia Autism Project, and we'd like to thank the patron, Delegate Watts, for once again bringing this bill. The Virginia Autism Project supports this bill. I will note that what we find is that when an individual encounters law enforcement officer, they do not believe they have discretion not to charge someone if they are scratched or hit or something like that occurs. So that would be the difference between someone going into crisis in a store where people are generally more understanding, law enforcement being involved, and then feeling like they have to charge if they are scratched or hit. So thank you so much, and we ask for your support of the bill.
Thank you. Next, Mrs. Jude Harrison.
Yes, thank you, Madam Chair. I'm Jude Harrison, Director of Communications for Decriminalized Developmental Disabilities, and we thank very much Delegate Watts for patroning this bill, and we so hope that you will approve it for all of the reasons you've heard here today. Thank you.
Thank you. Next is Lucy Bidnell.
Lucy Beednell for the ARC of Northern Virginia, and though we recognize there's not any bill that's allowing us to go back in time and change things, we support this bill because it allows us to, after the fact, go back, look at this situation again, put new tools in the toolkit, and look at things through a new lens, and give us an opportunity to allow that to drive the decisions that we make, which we think results in ultimately better policy. We strongly support the bill. Thank you to Delegate Watts for bringing it.
Thank you. Next we have Sheba Williams.
Yes, good evening. Thank you, Chair Watts and Committee. Sheba Williams with No Left Turns. I speak in my personal capacity. I have a 24-year-old son who is afraid to drive because of the Matthew Rushing case, where he was sentenced to 50 years for a car accident. Echolea is a very common thing amongst individuals with autism, so they can repeat a thing that they've heard before. I have watched my son. He is an architecture student at Hampton University, but he refuses to drive because of the fear of being criminalized for his actions that he may not have control of. For that reason, we support the bill, and we hope that you all will have compassion for Virginians who may not understand things the same way that everybody else does. Thank you.
Thank you. Next is Laura Kim.
Good evening. My name is Laura Kim. I'm from the Independent Center of Northern Virginia. We are a Center for Independent Living, working with people with various kinds of disabilities to live independently in their own communities, including individuals with intellectual and developmental disabilities. We urge you to support this bill and thank Delegate Watts for sponsoring it. Thank you.
Thank you. And then we have Nick McCurney.
Good afternoon, Madam Chair and members of the committee. I'm Nick McCready, and I'm the Executive Director of NAMI Virginia, and I would like to share that for all the reasons stated tonight, NAMI Virginia strongly supports this bill.
Thank you. And then registered to speak against the bill is Ann Tatus. Ann online? Okay. Seeing no other questions for the committee, Madam Chair, if you'd like to have the final word.
If it's now appropriate, let me address a couple of points. The idea that there are other ways to handle this. Yes, I have been working hard on other ways to handle it. Certainly crisis intervention being the first one, having mental health dockets, having deferred disposition so that we can use mental health dockets. Those are all part of what we need to be doing to try to deal with the wide variety of circumstances. But the circumstance before you is I am focusing just on felonious assault and battery. I am not focusing on misdemeanor assault and battery. This is only a possibility of an affirmative defense for felonious. Why felonious? Because of a lifetime record of having a felony and making it that much more difficult for the person to achieve the functionality that we all hope that we can bring forward for that person. So with that, I hope that this additional instrument in dealing with the wide variety of challenges that human beings who have mental illness, neurological issues, and the other enumerated conditions that this covers, that this will give an opportunity for a fair hearing by the court as to whether or not this charge should be pursued as a felonious charge as opposed to other appropriate action.
Thank you, Madam Chair. And if this bill does report, it does need to be a report and refer to appropriations.
So moved.
Second.
It's been moved and seconded to report and refer the bill to appropriations. The clerk will open the roll. And Madam Chair, would you like your vote cast as aye on your bill? Chair Watts? Do you want
Yes,
your vote
aye.
cast as, we'll register the chair as voting aye. All right, the clerk will close the roll, and the bill reports 7-3 to appropriations. Thank you, Madam Chair. And you also have House Bill 247.
HB 247, I don't believe there's any, there are amendments, if I could have them reported.
Do you hear move the amendment?
Move the amendments.
Second.
All right, all those in favor say aye. Aye. Any opposed? All right, the amendments are before us. Madam Chair.
If I could ask the clerk to report them, please.
Thank you, Madam Chair, members of the subcommittee. On line 14, it would be inserting other than section 19.2-298.02. This would be an exemption for that specific deferred disposition statute as opposed to all the other ones. And then after line 38 introduced, it's inserting a new subsection D that reads, no statement made by the defendant at a hearing pursuant to this section or during an examination conducted for the purposes of establishing the criteria listed in subsection A shall be admissible in any proceeding except that any such statement made under oath may be admissible in a criminal proceeding for perjury or may be used for the purpose of impeaching the defendant in the trial of any other criminal matter, provided that the testimony or evidence being used for such impeachment was produced by the defendant voluntarily.
Thank you. And it has been adopted. Again, this was offered to make sure that we've got the proper targeting of the bill. And the targeting of the bill, again, is still another element where it allows for the deferral and dismissal under an appropriate docket and the discipline of that docket, which, as VACA had indicated, this is where you focus on what the individual needs as far as services and making sure that what you're doing for the individual is the court directing of the services that this individual needs to receive. Again, as I have indicated in another bill on special dockets, these are challenging dockets. This means that the court really works with that individual most of the time for a year and longer to make sure that the individual is not only directed to the proper services and receiving them, but is responding, is learning the discipline that they need to be the functional individual that the court may feel at the end of the deferred disposition to dismiss the charges because of their participation in the program. And this is the bill that is before you.
Thank you, Madam Chair. Are there any questions from the committee? Seeing none. Oh, yes, Delegate Williams.
Question for the patron. Forgive me if I'm wrong, but nowadays in circuit court, if you want to try to do a deferred disposition, the Commonwealth would have to consent to that. Does this change at all? Does the Commonwealth have to consent to this deferred disposition arrangement, or no?
So again, I am not quite following your question.
She raised her hand. You got it.
The language of the bill already said that under this specific code section, that the court must find by a clear and convincing evidence standard that the criminal conduct was caused by or had a direct and substantial relationship to the person's disorder or disability. But they're supposed to, with the consent of the accused, the Commonwealth does not have to consent. The bill already said this, but the court is supposed to give due consideration to the position of the attorney for the Commonwealth and the views of the victim. So that language was already in there. It requires the court to consider that, but the Commonwealth does not have to consent to it. But this amendment doesn't change that.
And Delegate Williams, to that point as well, that's why the amendment was added for 19.2-298.02 to exclude it, because that statute specifically does say that for that deferred disposition, it's upon the agreement of the defendant and the Commonwealth attorney.
Okay, thank you. All right, seeing no other questions from the committee, if there's members of the audience here to speak in favor of the bill, if you could please come forward, and we'll put 4 minutes on the board to share.
Madam Chair, Delegate Watts, thank you for bringing this to the floor. My name is Brian Kelmar. I'm the president and co-founder of Decriminalized Developmental Disabilities. This process, we already have diversion in the criminal justice system. Right now, it's at the sentencing phase. What we're doing is taking it from there and just moving it up in the process. Right now, a person has to plead guilty or be found guilty before they can access diversion. That means they must accept a criminal record just to receive the supports they already agreed that they need. If the diversion is the outcome anyway, there's no reason to force people through months or court appearance that only worsen their mental health. For autistics and people with DD, this delay is especially harmful. Autistic people often perseverate, replaying stressful events hundreds of times intensely in their minds. And this causes things such as PTSD, depression, anxiety, and trauma. We have had some cases that have actually resulted in suicide because of this, just of the timing that it went on. We also know that diversion works. In the current legislation, we have tracked more than 150 cases who completed diversion over 10 years. The recidivism rate among that group is 0. When people get support instead of punishment, they can succeed. This bill also offers a path to expungement when diversion is successful. That is really important because developmentally disabled adults already face unemployment rates of 80 to 85%. Add a criminal record, and that number rises to about 98% unemployment. Without employment, they risk losing essential benefits under our upcoming federal work requirement policies. They could even lose capable of working, but they are capable of working with the right supports. Without early diversion, we push them into poverty, dependency through no fault of their own. This gives people a chance to stabilize early, avoid unnecessary trauma, and build a future where employment and dignity are possible. I hope that you improve this bill. Thank you.
Thank you.
Thank you. Tanya Milling, the ARC of Virginia. Yeah, this bill is part of really continuing work to bring greater fairness and justice to people with developmental disabilities, and it protects the access to often lifelong necessary services. So we hope you support this bill.
Thank you.
Good afternoon. Rebecca Herbig with the Disability Law Center of Virginia, and we support this bill.
Thank you.
Maisie Osteen, Legal Aid Justice Center, and for all the reasons that were stated, we support this bill and thank the patron for bringing it. Thank you.
Thank you. And anyone in the audience here to speak in opposition, please come forward.
Good evening again, Chairwoman. My name is Bethany Harrison, Commonwealth's Attorney for the City of Lynchburg, here on behalf of VACA in opposition to House Bill 247 because it creates an unusual procedure here that says anytime before or even after a plea that a separate hearing can be had to determine the appropriateness of a deferred disposition. And that's the evidentiary standard, appropriateness of a deferred disposition, which is vague and subjective. And here we have no time period on this, so it flies in the face of Rule 1.1, which is the finality of orders after 21 days. So someone can come in, enter a plea, be found guilty, and this broad language says anytime before or after a plea could ask for this hearing. Our judges, even under these taken under advisement statutes that we have, want to hear some substantive evidence of the case. So you end up having like a mini trial before the trial if we have it pre-trial, if we have this hearing pre-trial. And you have to bring in witnesses, or unless they're going to agree to some sort of proffer, and they would need to hear, the judge would need to hear all this evidence to determine that standard of appropriateness. So also you have here, if someone enters into a plea agreement based on this language, they could still request this. So for all these reasons, we are opposed to House Bill 247. Thank you.
Thank you. Okay, turning online. Speaking in favor of the bill, first I have Teresa Champion.
Hi, good afternoon. Thank you, Madam Chair, and I'd like to thank the patron Delegate Watts for this bill. With the Virginia Autism Project, we support this bill and ask for your support. We already have deferred disposition. It's at the end of the case. All this does is move it up and gives the judge discretion to consider it earlier. Thank you so much. We ask for your support.
Thank you. Next is Judy Harrison.
Hi. Thank you, Madam Chair. I'm Jude Harrison, Director of Communications for D3, Decriminalized Developmental Disabilities. And I'm speaking both as a mom and as a co-founder. So, you know, I wish that this bill had been a law when my son was going through this process. He would have greatly benefited from not all of the trauma of every continuance that he had to go through, everything being dragged out for as long as it did. I was glad that Brian brought up the issue of suicide. I've talked to a couple of parents who have lost their children to suicide, waiting for their trial to just happen. So we thank Delegate Watts for patroning this bill, and we surely hope that you will support it. Thank you.
Thank you. Next, I've got Lucy Bidnell.
Lucy Beadnell from the ARC of Northern Virginia. We strongly support this bill. We've spoken with several families who sold the family home, cashed out retirement accounts to keep a high-quality defense attorney who is familiar with disability, working and advocating for the person with a disability all the way through the process. And though I know any parent would choose to do that in a heartbeat, I think backing this up to save the courts time and money and making sure that we are protecting vulnerable people from going through dangerous traumatizing court processes and not having families lose their entire life savings and retirement trying to do what we could do more efficiently at the front is just smart policy. Thank you.
Thank you. Next is Sheba Williams.
Good evening, Madam Chair and Committee. Sheba Williams with No Left Turns. Obviously, as someone who has worked really hard on the expungement bill for people with convictions, we support this, but also mother, supporter of people in our community who should not live with a record for the rest of their lives. The economic impact, the economic terrorism of having to go through the process is enough on a person who does not have a disability. So, for that reason, I support the bill, and thank you for your time.
Thank you. And then we have Laura Kim.
Good afternoon. Laura Kim from the Independent Center of Northern Virginia. For all of the reasons stated before me, we urge support for this bill, and thank you, Delegate Watts, for sponsoring it.
All right, thank you. And registered to speak against, we have Ann Tatus. Ann Tatus online? Okay. All right, I have a question on the board from Delegate Williams.
Yeah, Madam Chair, speaking to the bill.
Delegate Williams, you have the floor.
I know you've been working hard on this stuff, and it's very technical. And like, I'm pretty close to like being behind you on a lot of the different things. I would like to see it kind of cleaned up with the like timing of when they can do some stuff. So I can't get totally behind it, but definitely on board with where you're trying to head.
If I may respond, Madam
Chair, yes, you have the floor.
As I understand your question, I'm looking at the language in the bill and my understanding of deferred disposition. Deferred disposition is granted upon the determination that the person would be found guilty or has been found guilty. So that's where the timing comes in as I look at that circumstance, so that the individual can, before or after the plea, request the deferred disposition. That if the hearing occurs before the plea, you've got to enter the appropriate evidence that would indicate guilt prior to deferred disposition. So I'm not puzzled by having those entry points of when you might request deferred disposition, and the court has the determination of whether it thinks this case is appropriate for deferred disposition.
Thank you. And Madam Chair, would you like to make any other closing remarks before we open for a motion?
Other than really the answer to Delegate Williams' question was something that I wanted to express, and other than that, I'm going to restate, you heard all the need out there. I have really found that the deferred disposition focus on the well-being, restoring the person's functionality through intensive work for at least a year's period is exactly what so many of these individuals really need, not just a few weeks, but they really need that focused concentration, and the court can direct and offer this.
Thank you, Madam Chair. If this bill reports favorably, it would need to go to appropriation, so now would be the appropriate time for motion.
Move to report as amended and refer to appropriation.
Second that.
Moved and seconded. The clerk will open the roll. And Madam Chair, Watts will have
Yes,
the clerk
please.
record you as an aye. Go ahead. All right, the clerk will close the roll. The bill reports and is referred to appropriations by a vote of 8-2. Thank you, Madam Chair.
Thank you, and you can bring it on.
And I'll go ahead and, since you're still at the podium, do we hear a motion to adjourn?
So moved.
Moved and seconded to adjourn. All those in favor say aye. Any opposed? All right, we are adjourned.